A131379, Nikolai Shaparov versus AffinityLifestyles.com.
Go ahead and state your appearances.
Yes, Your Honor. Theodore Parker and eventually Eric Pepperman and Breanna Switzler on behalf of the plaintiffs. Thank you, Your Honor.
Good afternoon, Your Honor. Michael Esposito, Tyler Watson, Gina Mushmack, and Bradley Johnson, Marta Dunning, Richard Bryant, and Jake Suty for Real Water.
That was impressive.
I'm working.
Eric Freeman for Real Water as well.
Good afternoon.
Nate Arrington on behalf of ETT1 and Jim Cavanaugh will be here momentarily.
Okay. All right. Well, you want to hear my thoughts first?
Yes, Your Honor.
Yes.
Okay. Which ones are we starting with?
33, Your Honor, which is plaintiff motion number 31.
Okay. Trying to read my notes, so I apologize. Yeah, so this is one that often happens still today. Stream providers are experts, but they don't have to do reports. So I think there's even a case where the Nevada Supreme Court kind of didn't express that, but stream providers are experts. They just don't have to do reports so long as they're ID'd as experts and they meet the disclosure requirements of 16.1 A2A and A2C. So the first question, was that disclosure rule complied with? So they are being offered, I think, as treating physicians as experts, but I don't know that any of them reviewed hydrazine or real water materials. So they wouldn't be, limited to opinions forming course and scope of treatment. Include treating physicians. But yeah, so one, I don't know that they were actually identified as experts, because if they weren't, then they're not experts, maybe. And if they didn't review real water and hydrazine, then they can't offer opinions on that. So that's probably a way of saying I'm inclined to grant that, but the phrasing, welcome arguments on, I guess. After that is place motion limit 34. Is that the next one?
Yes, Your Honor.
Okay. This one, my note's pretty simple. Grant for all the reasons in that motion. Next, place motion limit 33, grant. Place motion limit 35, grant. Place motion limit 37. Grant in part to preclude reference to the bankruptcy. I don't know, in terms of closed or small company, that's probably more appropriately addressed. Question by question, answer by answer. I think some of that evidence is probably gonna come out. And I know in our case, apparently they Real Water kept emphasizing that, and that's when I cut them off, I think, is kind of how it read to me. So I'd be inclined to grant in part, deny in part, and of course, if somebody thinks there's too much of any particular thing, make your objection and rule on that. Place motion on the 40. Okay, so I'm probably inclined to deny this, but it might, this one was a little hard to track for me, in all candor. I think the photo micrographs are taken from pathology slides that were previously produced and disclosed. And so I'm probably inclined to deny number 40, but again, my notes, I have questions that I may have already think answered to myself, maybe. So I welcome arguments, but I'm probably inclined to deny that one. 41. That one's grant is unopposed. 42. Grant. Here's my note. Quote, sometimes you just get smarter with age, close quote, is not good cause or a legitimate reason to change an opinion. He could fill me in more and remind me more of why I may have written that, but I think I kind of remember.
You nailed it.
I was telling my law clerk on the way in here, 25 motions a day is an awful lot to try and remember by one person. Let's 43 pre-admit marketing videos and still add. This one probably inclined to grant. I think, the business plan, certainly business record. I think the foundation for the videos and ads probably also laid by the business records themselves. So probably inclined to grant that one. What number was that? This is the next 40. Say that again.
Plaintiff's motion limit 44 to preclude certain opinions of Glenn W. Purdue.
Okay, so so this is number 44. My note is welcome arguments. Maybe grant part, deny in part, but there you go. That's definitely one argument's on. Yeah, that one is all of that right there. This motion limit 45. Strike produce untimely supplemental rebuttal report. Probably inclined to deny. My note says I can't tell from plaintiff's briefs when the $2 billion report was disclosed in this case. Yeah, I remember this one a little bit at least. I remember, yeah, trying to figure out what plaintiffs' representations were based on in terms of the exhibits, and I had a hard time following that. So, I think I said I'm probably inclined to deny that one. Plaintiff's motion would be 46, exclude or limit Howard Moss. Inclined to grant in part, exclude him from testifying regarding causation of liver damages and or cirrhosis. Deny in part, he can testify about, alcohol use disorder and evidence in support of that. I think that issue goes to weight. And goes to one, yeah, anyway. 48. Grant that one is beneficial. Oh. Okay, let's keep going. Nevada beverage motion partial summary judgment punitive damages. I don't know that that one's still live in front of me, but if it is, I'm inclined to deny without prejudice because genuine issues of material fact exist. Nevada beverage motion to strike Herbst plaintiff complaint for spoliation. I'm not sure that's live, but if it is, I'm inclined to deny that. Nevada beverage motion limit 1 pre-admit evidence. Pre-admit evidence that Nevada beverage employees consume real water for years without issue. Inclined to grant that the motion limit, my note says, and I think plaintiffs argued otherwise, but my note says the motion limiting joined or identified specific employees that they're basing the motion on. So inclined to grant that. Nevada beverage motion limiting number 2 pre-admit volume of real water distributed. I have grant with a question mark, so inclined to grant it, but welcome arguments. Nevada beverage motion limit 3 exclude evidence of hydrazine test results, speculative expert opinion about it, deny, handle it on a question by question, answer by answer basis. No, okay. Nevada beverage motion limit 21. Trying to deny that. You probably can tell if I don't give you reasons right now. It's pretty straightforward in my opinion. Um, The bad beverage motion will be 4, preclude plaintiff's counsel from asking questions and making arguments based on the reptile theory. Inclined to deny. Little smile because I haven't had this one in several years. We used to get them all the time. But inclined to deny that. Number 5, exclude reference hydrazine as rocket fuel. Good college try, but inclined to deny it. Number 6, exclude reference to the Russians. Inclined to deny that one. Yes, bad beverage 7, exclude 30B6. You might have to jog my memory on this one. Let's see.
This one we can vote you on.
Oh. Okay,
This is the bad beverage 30B6 witness.
okay.
Yes, Your Honor, we don't intend to introduce this testimony because Nevada Beverage settled, so I think that one is moot.
Okay with that.
Maybe we could meet and confer with plaintiff's counsel on that. It may have implications for other defendants.
Okay.
Oh, I mean, if we're inclined to grant it, if they're offering up that they're not going to introduce it, then I think we can just grant that as unopposed and move on.
That's what I would think, because you're okay excluding that testimony, right? Them, I'm asking them, I know you.
Caught me on
It
that.
sounded better when it was vote, Your Honor.
Okay,
We'll meet and confer.
well, I guess I'd be inclined to grant it, but welcome. I mean, if it was still an open issue, I'd probably be inclined to deny is what my note says, but if it's unopposed now. Okay. 8, exclude unfairly prejudicial imagery. Oh yeah, the images. A grant in part to exclude on voir dire and opening. Except you could use the United States rocket image on that, perhaps. You could also switch to some image that's innocuous is the word I would use, but deny it because I think in closing, I think those images are, appropriate support for an argument. Because openings and voir dire are different than closing arguments. 9, exclude Blaine Jones injuries valuation claim, to deny that one. Oh, yeah. Okay. Yeah, so on Catherine Donnelly, I haven't had the time to go back.
We probably get that on the 14th.
We have two on the 14th. This one I thought was tomorrow, but I probably heard Amanda wrong. But either way, Your Honor, if we want to speed things up a little bit, the question I think we both had is, we were told the court was inviting additional argument, but not as to what nuanced point. And if there is a specific question the court is asking us to answer, that might take a matter of seconds as opposed to just.
I wish, as I sat here, I could even answer that one. I was preparing for other hearings and just ran out of.
What other cases?
You know, ironically, it's, 99% your case, but yeah. So let's see which,
Can we meet and confirm and see?
oh, yeah, good, yes, thank you, yes, yes, yeah, take 10, let's go off 10 minutes, yeah,
Thank you, Your Honor.
thank you. An hour and 15 or 20 minutes. That really, is my math wrong? If I don't speak, well, here, give yourself an hour and 10 minutes, because I'm gonna probably talk, so. And I'll count on your colleagues to remind you.
Your Honor, I'm nothing if not self-aware. At the risk of wasting time, I do want to say thank you, Your Honor, to you and your staff. I mean, the preparation that goes into this, we recognize how much work it is, and it has made a huge difference in facilitating things. And I'm sorry for previously not showing you the same respect with my time, but I promise I will go forward.
Okay.
Your Honor, your inclination was to grant this one. You did have a couple questions. I just wanted to clarify those. One being, you weren't sure if they had designated any of the treating physicians as experts. They did not. No treating physicians were designated as experts by defendants, which further confirms your inclination is correct. And a second clarification on this is your ruling was if they didn't review hydrazine materials or consider hydrazine, they can't give causation opinions.
Yeah, they lack foundation. Right?
Yes, Your Honor. And I just want to clarify that what this motion is they're not seeking to give an opinion directly related to hydrazine. They're seeking to introduce their treating physician diagnoses that there was some other cause, mostly alcohol with Mr. Herbst, without having considered hydrazine. And so it's that opinion that is what we're seeking to exclude. It's that opinion that's a causation opinion that wasn't formed during the course and scope of treatment because they didn't know about hydrazine, they didn't review hydrazine, they didn't consider hydrazine. And so if they wanted a treating physician to give any opinion relating to hydrazine, whether it's in or out or something in between, they were required to file expert reports and designate the treating physician as experts. They did not do that, so your inclination is correct. And I will reserve.
Thank you. Sure.
Okay. First, sorry, Nate Arrington appearing on behalf of ETT. The first motion, limine 31 and 34, the court has already ruled that with regard to the treating physician records, those are admissible, and that's pursuant to FCH 1 versus Rodriguez, a Supreme Court of Nevada ruling. Likewise, in Wynn versus Napa, the same ruling came in, which is if they're treating physicians and they're providing records at the time that they were being treated, that comes in. And our position is that even if they provide causation evidence, by way of example, if they indicate that you're drinking alcohol and that could cause you death, which in fact is in there, that's something that should be admissible. I don't disagree, they were not aware of hydrazine being there, but that only means they can't provide an opinion with regard to whether or not he was drinking alcohol and whether or not the alcohol was in fact injuring his liver. Those were the determinations that are written in the treating physician's records. So therefore, yes, they don't have any information regarding hydrazine or real water in any of the records that Mr. Herbst had. But that doesn't mean that he's excluded, that we are excluded from putting in the doctor's opinions as to what was causing the injury to his liver.
Well, that may go to the first step, you know, because I guess I have a quote from you all. Opposition, page 5, line 25, said something effective, defendants, and I may have misquoted, but are not offering the treating physicians as experts.
That's correct. They're not being considered as experts, they're being considered as treating physicians, and what they say
But
in
see,
their
that goes to the
reports.
disconnect. And I'm trying to think of how to better explain it. You have different experts. You have reporting experts. This is my characterization, but you have experts who have to provide reports. You have other experts who do not have to do reports. Those often are, not always, but often are treating physicians. Because you have them in here, you know, as experts in medicine. So when you all say, well, we're not offering them as experts, I'm not sure that's accurate. Do you see what I'm saying? Because I'm not
I
sure.
see what you're saying, but it's a little different, which is at the time they were being treated, the doctors provided the information that they were aware of. This is a simple factual dispute. And under another Supreme Court case, if you have a simple factual dispute with regard to whether or not real water caused an injury, which we would not provide any opinions on, versus a doctor stating this is because you're drinking alcohol and it's injuring your liver.
But that's an expert opinion by that doctor, right?
But that's written in the treating records, and it specifically is provided to some extent by Mr. Herbst too.
No, I don't disagree with it. Well, I'll stop talking because I'm eating into your minutes, but you know, I'm not sure we're on the same page in terms of generally treating, well, here I'm talking, generally treating physicians would be considered experts. They just don't have to do reports, but you do have to comply with the other disclosure rules, which plaintiffs are saying you never did.
If in fact the record was created before the litigation was filed, and it was part of the treatment for Mr. Herbst, that information should be admissible as a treating physician record, as opposed to an expert report where a person, as part of the litigation, is creating a record and also is providing their own opinions. That's very different from a treating physician who is focused in on one person and identifying what the cause is of his malady. And so therefore, it seems to me that if a doctor has opinions with regard to this specific patient, that is still admissible as a treating physician record, as opposed to somebody who comes in as part of the litigation, doesn't really treat the person. That's something different. And I agree, for that, you need an expert's report. But as long as it's something that's part of the treating physician's scope of work and providing opinions as part of the treating physician's scope of work, that's something that should be admissible. It's completely outside of any expert witness. So therefore, our position is, if it's in the document that was used to treat Mr. Herbst, all of those words get to come in. Do you have any other questions for me?
No other questions. Thank you.
Thank you, sir.
Your Honor, I don't believe that your question was answered because I think Your Honor sees this for what it is. You're exactly right. Treating physician attempting to opine on causation is an expert. They are either have to produce a report or they don't have to produce a report, but it's still expert testimony. And if they don't have produce a report, you still have to designate them as an expert, and there are other requirements under Rule 16.1A2. Defendants didn't do any of that. They didn't designate them as experts. They didn't say that they were going to testify as experts. They didn't meet any of the requirements. That alone dooms their ability to call them to give expert testimony. But even if they had done that, it still would have been a situation where they have to provide a report because they're purporting to have them give an opinion as to causation over something that they did not review or know about during the course of treatment. That, in that instance, you have to produce a report because it requires you to say, this is what I considered, this is what I reviewed, these are the bases and reasons for my causation opinions. They did not do any of that. Mr. Arrington did not cite any law. The FCH1 LLC v. Rodriguez case is very clear, exactly as Your Honor characterized it. I know that you specified that that was your characterization, but that's the correct characterization of Nevada law. And this is true with the medical records. I'm not sure what Mr. Arrington was saying about the court already ruled that medical records are in as to causation. But regardless of the admissibility of any medical records, you can't get in unfounded, inappropriate, undisclosed
Let me
expert opinions.
ask you on the medical records, are there ones that you all have either stipulated to admit or are planning to seek admission of, or is that an issue for some other time?
It's an issue for some other time. I'm sure both sides will want to admit certain medical records. We haven't discussed the scope of that yet. I think a big reason is we're making sure we have an understanding of the court's rulings on these because that'll really inform it. And that's the same with this motion. I mean, just because a motion is granted like this one doesn't mean that every medical record is inadmissible. It just means that certain aspects of it may need a redaction, which is very routine and not that, like I said, that's an issue for another day. So unless Your Honor has any other questions, I would submit on that.
No other questions. You touched on one thing I had thought of in terms of the records is, potential admission and or potential redactions. Not what I'm doing right now. You're making me nervous. Why are you standing?
I apologize.
Oh, that's okay. Okay.
I would like to make a quick point, just that the medical records are business records, and so therefore they all come in. And also, because these are factual disputes, they're essentially trying to make it so that we can't try our side of the case. The fact that the records say one thing and the fact that they have differing opinions on the other side, that's something that a jury should try, not something that should be precluded.
Do you want to offer anything in response?
No, Your Honor.
Okay. Yeah, so there is certainly a disconnect between me and the defense argument. I'm repeating myself, but this disconnect, treating physicians are experts. And especially if, you know, yeah, there's always exceptions to rules, okay, but generally speaking, yeah, they are experts. And especially here where defendants want to rely on them for opinions as to causation, like Mr. Herbst's alcohol consumption caused liver damage or cirrhosis or what have you. Those are expert opinions. And the fact that defendants are still arguing, even right now, after I've tried to clarify that they're not experts, in case you can't tell, I'm struggling to understand that argument, because they're experts. Now, they're what I would call non-reporting experts generally, where they don't have to issue reports under certain circumstances, but you still have to comply with the rules. And, you know, I don't know how else to put it, but defense. So the court grants the motion. The treating physicians, et cetera, were not designated as experts, so you have a lack of compliance with 16.1A2, you know, subsection A, subsection C, and subsection D even potentially. But there, if you read the rule, there's these requirements in there, and that is there for situations like this. So they had to have been disclosed as experts, which defendants didn't do. So that's a basis. Substantively, the basis as well is there's a lack of foundation for any causation opinions, because they, and I'm not faulting these doctors, to be clear, they did not consider there's a hydrazine and its consumption. Defendants are indeed trying to offer the trained physicians as experts, contrary to what they're saying, but they didn't comply with the disclosure rules, and certainly there's also substantially a lack of foundation. Yeah, I still try to explain myself, but I think I've done as best I can on that. So, okay. 34.
Your Honor, your inclination was to grant this one, and I'll reserve.
Okay.
For the same reasons that the court ruled on 31, correct?
Yeah, it's similar. Yeah. So the court grants number 34 for the reasons given, and also the reasons in the motion reply. Okay. Which one is next? 35? Life expectancy table one.
Your Honor, you were inclined to grant this one, so we'll reserve.
Afternoon again, Your Honor. Jim Cavanaugh for ETT1 DBA Terrible Herbst. Just briefly, the reasons why standard life expectancy should not apply is that they're not relevant in this particular case, and it's not relevant evidence that shouldn't be admitted. Plaintiff had a shortened life, substantially shortened, because he had advanced alcohol-related liver disease. Whether it was a thin eggshell plaintiff situation or not, he clearly had alcohol-related liver disease. He had previously long years bout cancer, had a many years record of colon cancer. And so in light of the damage claims by this particular plaintiff, Milo Herbst, the Herbst plaintiffs on his behalf and their behalf, in light of his individual health, his habits, his activities and lifestyle, his occupation, owning a bar, 2 bars, and the many years of medical records, irrespective of that, you can't evaluate damages comparable to an average when you have a plaintiff that's so far removed from what I would believe would be average. So in a nutshell, that's it, Your Honor. I don't think a standard life expectancy table is at all appropriate, and there's no foundation. No expert has said on behalf of plaintiffs that a standard life expectancy table should apply to this plaintiff. This is just something they're pulling out of a book, offering it up as evidence to affect the damage claims they're making. And that's, again, it's irrelevant and it should not be admitted. Any questions, Your Honor? Be happy to submit all the papers after that.
No questions. Thank you.
Thank you.
Briefly, Your Honor, obviously, we would, don't want to waste a bunch of time counteracting certain evidence that Mr. Cavanaugh brought up as far as lifestyle circumstances. Obviously, the court is very well aware of that, so I'm not going to waste time on that aspect of it. The point that I think was not addressed in any capacity too is that these standard life expectancy tables, if there's a jury instruction for it, right? Anytime there's a wrongful death claim or anything like that, this is at issue. Our expert has opined that real water was the cause of his untimely death. There lies the foundation for it there. We cite in our reply on page 2 and page 3, a number of different court cases that suggest that simply because someone might have, quote, less than normal, or otherwise, you know, if they are arguing has a poorer health than someone who's average, that doesn't go to the admissibility of these. And so that's why exactly your inclination was correct, and we would request that this motion be granted. Unless you have any questions, I'll sit down.
No questions. Thank you. So the court grants plaintiff's motion limine number 35 for the reasons detailed in the motion and reply. The records are relevant. You know, the standard table certainly. Now the issues raised go to weight, potential for, you know, cross-examination, impeachment, but not reason to not go ahead and pre-admit them, as I generally do anyway. So that one's granted.
Thank you, Your Honor.
Thank you. 37.
Correct, Your Honor.
Oh, yeah. Okay. Oh, I guess it's still your side.
I was just gonna say, I think I'll briefly discuss, just because I was looking over my notes, sorry. Obviously, we would very much agree with this court's inclination as it relates to the bankruptcy. I think the closure also kind of falls within that same regard. I know Your Honor had mentioned something different. Detailing that the business is closed is basically waving a red flag to the jury saying we're closed, we don't have money, which is the same thing as them saying we're bankrupt, we're bankrupt, we're bankrupt. And so this is another thing that we're looking at is, and I believe Your Honor did recall, you know, the small company regard in the prior run case. You know, they kept saying, we're a small company, we're a small company, we're a small company, we're family owned, we're this teeny tiny company. And that's what we're trying to prevent is because they over and over and over again. And that's just, like I said, they're just basically waving red flags before the jury saying, we don't have money, we cannot pay. And as the court's probably very familiar, the ability to pay, especially in compensatory damages, is something that is not permitted at all. The case law is very clear on that. And So that's why we also argue that the small company and the closure shouldn't be, is because it's very akin to, especially in the compensatory phase, the same reasons apply to the bankruptcy. And unless the court has questions, I'm just wanted to reemphasize that, and then I'll save the rest of my time for rebuttal.
Thank you.
Your Honor, Michael Esposito, on behalf of Real Water. Of all the motions that we have before the court, I think this one is the one that is the most rife with potential appellate issues, and for good reason. One, I do tend to agree with plaintiff's counsel that repeatedly referencing the ability to pay during the compensatory damages phase is inappropriate. So I think we can get that off the table right now. As far as the bankruptcy goes, and Your Honor, I'd like to split this up briefly into the bankruptcy and then the size of the company during operation. And for the clarity of the record, Your Honor, financial condition is different than size of the company for Real Water during operations, right? There's a significant difference between they had one quality control guy, they only had 12 employees, I'm making numbers up, but right, like, and I think one of the material changes here between Watson and now is that there's a HACCP expert in play, Catherine Donnelly, who has provided the court with a detailed summary of why the size of the company during operation matters and why that is directly implicated on questions, whether or not we're talking about the reprehensibility of the conduct, whether or not the hazard analysis would have yielded that the hydrazine in the water was foreseeable. There are a lot of these issues where Catherine Donnelly sets down and says, size of the company has always been important to the regulatory bodies. It has demonstrably impacted certain companies' ability to implement certain protections.
So is that an argument that if it's a small company, it's free to distribute poison to people? I mean,
No,
that's
absolutely
kind of
not.
a slippery slope maybe, but you're kind of losing me there on, it's a small company, it doesn't have to comply with the law.
Absolutely not, Your Honor. That's not what I'm saying.
Okay.
Not even remotely.
Okay.
No, I understand the court's concern, but that's not remotely what we're talking about here. The point for this motion, Your Honor, is that when it's in the compensatory phase, we have experts that need to talk about the size of the company when it is in operation, and they're going to put it into context that obviously I'm not doing justice here. But whether or not it's relevant to the case, it absolutely is relevant to the case, regardless of whether or not Real Water now can pay a judgment. So I think the court's inclination to allow the size of the company, the financial details of the company while it was in operation is absolutely correct. The problem that we run into here, Your Honor, is with the bankruptcy. Now, there's good law in Nevada on this, and I think it's been ignored to date. We have Gidney, we have Allen, we have multiple case law in Nevada, and I'm going to quote directly from the case here that says, a finder of fact must take into consideration whether or not punitive damages award would actually punish the tortfeasor. That's Gidney v. Marion, 98 Nevada 54, Penn site 56. That was decided in 1982. Opposing counsel gets up and they argue that, well, there's no punishment component because they're in bankruptcy, so it's irrelevant. The problem is that the Nevada Supreme Court has looked at this in a variety of contexts, whether it's an estate, whether or not it's receivership, and said the context doesn't matter. What matters here is that you can't bifurcate punishment and deterrence. You can't say we're only going to pay attention to one of the two public policy prongs of punitive damages. You have to consider both. The statute actually says you have to consider the financial condition of the defendant. And so building upon that, the Nevada Supreme Court has said that a finder of fact must consider whether or not the defendant would actually be punished by punitive damages award. So this entire notion that you can separate punishment from deterrence, and you can say, well, they're in bankruptcy, so punishment no longer matters, is completely contrary to decades of precedent in Nevada. And that's really what I think the massive appellate issue here is. And not to mention, Your Honor, and we make argument, but I will defer to the court on how much you really want to hear about this, but I had the opportunity to pose Mark Rich this time around. And I asked them, what did you consider? Did you consider just deterrence, or did you consider deterrence and punishment? And Mark Rich, their own expert, says, oh yeah, I considered punishment prong. That's in my notes, that's in my valuation. So as a practical matter, how is it that Real Water isn't able to discuss the punishment component according to the plaintiffs? But their own expert has provided this information to the jury time after time after time, and is just now finally admitting 5 trials in that punishment has been a factor. We went even further. We asked him if he considered the financial condition. Now, he gets a little squirrely on this, and I think you've seen that in the moving papers. But Mark Rich says out of one side of his mouth, no, I didn't consider Royal Water's financial condition. But then he says, but I absolutely considered the fact they have somebody paying their bills. They have money coming in from somewhere. Heck yes, I considered that. You don't have to take my word for it, Your Honor. In the opposition, we provide you the black and white of Mark Rich's testimony about what he considered. So as a matter of law, even if it's just during the punitive damages phase, and I think this might be a fair and legally correct way of doing this, Your Honor. Real Water needs to, at the very least, during the punitive damages phase, should we get there, provide the finder of fact with the information about the financial condition of the company and the fact that the company is in bankruptcy. That's Gidney, that's Allen, that's the black and white of the statute. If the court's inclined to limit any reference to the bankruptcy during the compensatory damages phase, we can live with that. We can even live with the fact that we are not going to get up and say, Real Water can't pay these bills. It's not part of the trial plan as I know it. And frankly, I think that plaintiff's counsel is correct when she says that that's would be inappropriate. But we need to be able to get up and say, Real Water had X amount of employees. Real Water was a family-owned company with husband and wife at the top, their son doing the day-to-day operations. They had nobody else, so that when they needed a HACCP person to go get HACCP trained, guess what they did? They sent Blaine Jones. The expansiveness of saying that we can't talk about the size or financial condition of the company at all imposes a wealth of different restrictions on that kind of testimony that's absolutely material to this case. So, Your Honor, my inclination, listen to me, my recommendation to the court, if the court's inclined to hear it, would be follow the court's inclination on the financial condition. Well, not the financial condition, excuse me, but the size of the company, how long the company was open, or when the company started operations, how many employees they had, the general financial information of the company when it was in operation. I think is fair game.
But even the financial condition of the company while in operation, how would that come in during a non-punitive damages phase?
Well, and Your Honor, I think that's where we need to be, and we've done this before, this exercise, right, of being a little bit more specific in the terminology that we're using, right? This is the liability causation issue all over again. If Real Water can get up and talk about the amount of sales that they were doing, the reach of the distribution, how many employees they had, the factors that Catherine Donnelly takes into account in her report, that's fine. But if we have to exclude Real Water had no money in 2021 to pay a judgment, or Real Water has no money now, that's fine too. During the compensatory damages phase, if we can't talk about the current condition of Real Water, but we're allowed to talk about the operating condition of Real Water, when it was open, when it was operating, I think that speaks to the issues that our expert raises without running afoul of the prohibition on talking about whether or not they can actually pay the bill or the judgment. So again, we get back to that whole compensatory damages. We talk about when it was in operation. We say, you know, they had X amount of employees, they were in business for this long, they were in these markets, they had X amount of distributors, X amount of bottles of water, X amount of 5-gallon jug delivery routes, things like that. When it comes time for punitive damages, should we get there? That's when Real Water needs to be able to say, according to Gidney, the jury, the finder of fact, must be aware that there will not be a punishment against Real Water here based on the judgment that they're trying to enter. That is an affirmative obligation that a finder of fact must take into consideration whether or not punitive damages award would actually punish the tortfeasor. That's citation directly from Gidney. So, Your Honor, if we're talking about the compensatory phase, again, limiting it to operational details, perfectly fine. Once we get into, or if we get into punitive damages phase, allowing the bankruptcy in complies with Nevada law. Allowing the financial condition of the company generally, the fact that it's closed, follows Nevada law. But I'm perfectly fine if the court's inclined to say we can't reference the closure during the compensatory phase, to say, okay, we'll take that. Because realistically, what we need to talk about is for punitive damages, knowledge of the company, knowledge of the employees, reprehensibility, is what were they doing and what were they able to do while they were operating? And the court may be inclined to say that whatever defense Real Water wants to put up is, not preferable or not believable or what, wherever the court is based on the testimony it's heard in the prior trial, but that doesn't mean that Real Water can't be afforded the opportunity to present their complete defense.
Oh, thank you.
Thank you, Ron.
That was a lot, so I'm gonna break it down because it sounds like some things were being conflated. First, as to Mark Rich, we put back in our reply the question and answer since I didn't block quote it. They actually said, what factors can an expert consider? And Mark Rich listed a number of things. That's not saying he actually considered those in the case. That's completely wrong. And then he exactly flat out says that he cannot. I don't have any information on that as far as actually considering Real Water financials. So clearing that up. Council also cites to Gidney. This is Gidney. It's not even 2
Early
pages.
1980s Nevada Supreme Court.
Correct, and not criticizing obviously the court, just pointing it out that the analysis isn't actually.
I'll go ahead and say it, lacking.
Correct, and actually doesn't really support what the defendants are saying in any way, shape, or form. In fact, the word financial condition, financials, nothing like that is actually even cited in that opinion. Which is why it lends no support to their actual arguments. It's also distinguishable on many different reasons because it's a receivership. And all the court did there was they said, hey, you might want to consider the receivership. I'm sending this back down. They didn't actually say, that you had to consider the financial condition in any way, shape, or form. Allen, the other side that they case, was subrogated by law. I don't understand. They can't rely on that. That's not good law to say that, hey, and it's also a dead person, not a dead company, which are actually very distinguishable because we have a set of, laws related to a dead bank or a dead company, different laws as far as business court knows, which dishonor is very understandable about. The other thing that's interesting is, I think Your Honor actually hit it right on the point when you're like, is she saying that because they didn't have employees that they could violate all the, yeah, that's exactly what she's saying. That's exactly why they want to just keep saying this over and over again. They're saying, oh, no one told us how to actually comply with law, so we didn't actually comply with law. And so because we never complied with law, we should be able to say that it's a small company and we should be forgiven. And that's, again, that's what they're at least saying that they're doing. But again, that has no relevance here. What Real Water wants to do and what counsel said is, oh, if we need to, talk about what it was in operation. That's a fiction. That's a fantasy that they want to present to the jury that doesn't actually exist. This entire argument, as far as the bankruptcy and all that stuff goes, is lying to the jury. And the reason is because plaintiffs actually stipulated to not go after any of the assets of Real Water. So any asset of Real Water is not relevant. It actually
Strenuously object to any implication that we're asking to be lying to the jury. I think that's beyond the pale as far as counsel to counsel goes.
So this is when we pause the time. Yeah, put this toward my speaking time. I mean, there are a couple things. One, I'm not and maybe I've said this here, maybe not, but generally speaking, I'm not a fan of, attorneys saying the other side's lying or.
I apologize, Your Honor.
Well, no, so I've got a couple more words to say. So bear with my slow talking for a few moments. You're zealous advocates for opposing sides. Nothing even remotely close to what I've seen either in the first trial or this one so far. We go to that type of level. You can choose your words more carefully, although I often say, saying counsel's disingenuous is just an attorney's way of saying counsel's lying. So don't use that. But I understand the point in terms of the facts. the bankruptcy and the stipulation regarding going after what kind of assets. So, other point though, so that's to plaintiff's counsel, the point to defense counsel. Another thing I often say at arguments, and I look over there, I don't see anybody sitting over in those chairs to my left. We're not in a trial. This is not the time to whether strenuously or not. One day I'll hear I object, but not strenuously, but you know, now's not the time to interrupt counsel's arguments with objections. So those are my words of advice to both sides going forward. In any event, that cut that against my time. Go ahead.
All right, so getting back to where we are, so we go through all the reasons in our briefing, and I don't want to go through all this stuff as far as why the financial condition is completely not relevant here. And that's because we stipulated that nothing related to the bankruptcy is actually at issue. So what Real Water wants to do is present to the jury, hey, we are bankrupt, we're out of business, we're this poor little small company, we can't pay, when actually that has nothing to do with the issues at hand. And this is exactly why Real Water previously, and I don't know if we want to argue estoppel here, but have actually said to this court and many previous courts, is why we cited to it in our brief saying, hey, yeah, the bankruptcy can't come in, that can't come in. And they cite to the Capriati case. And the Capriati case says if they want to introduce the fact of their bankruptcy, thereby, and this is a quote, Capriati first introduced evidence of its bankruptcy, thereby suggesting that it was unable to pay a judgment. Thus, to cure the resulting prejudice, underlying prejudice there is my emphasis, the district court appropriately instructed that the jury that Capriati had liability insurance to satisfy any judgment. And so if they want to say, oh, we can't pay, okay, we'll bring up Liberty. We'll say they have $156 billion in assets. We can say there's plenty of people who can pay. And that's what highlights the irrelevancy of the argument that they're seeking to present, is the financial condition and the fact that they're closed has absolutely nothing to do with this case because they're not actually on the hook for anything. And so that's why in the compensatory and in the punitive, as this court has already ruled, he ruled on this issue as far as the bankruptcy stuff before and said that it doesn't come in as far as the punitive damage.
The other trial or this?
Correct.
Okay. Yeah, because I thought I did in the other trial.
You did, and we cite that in our opposition. As far as that goes, I can, the reply, I'm sorry. Actually, I believe in our motion as well, both of them. Cite to your previous rulings as far as that goes. And so that's exactly why this whole idea of financial condition, bankruptcy, and them being a small company, all it is trying to suggest that they can't pay. And that's A, not relevant because of the bankruptcy stipulation and other reasons that we set forth. B, you can't say that you can't pay in compensatory. That's directly against Nevada law. And B, their case citations to Gidney and Allen have actually zero support for the positions that they're saying. And actually, like I said, abrogated, have been abrogated under statute. So that's exactly why we are arguing and saying that our motion should be granted in full, because it has no place here.
Thank you very much. So, yeah, when I see a 1982 Nevada case, even though it's not as old as I am, there was a tendency to do, and I don't fault them at all, it's just how it was, short opinions that, were lacking in thorough analyses, I guess is a way to put it. And every case is different on what facts we're dealing with and what evidence, so the court largely sticks with its initial inclination, modifies it a bit, so grants it in part to preclude mention of the bankruptcy and anything related to bankruptcy. Grants in part to exclude evidence argument that Real Water is out of business and or closed. Denies in part, the small company. I am still pending the motion on Catherine Donnelly, but I have to tell you, those arguments on the defense side give me more concern maybe. But we'll still deal with that. But the small company, I think, fact and evidence wise is probably going to come fairly into play, at least to a limited extent. I still have a concern that I may have to deal with it like I did in the other trial. But I'll rely on plaintiffs' counsel to make appropriate objections when they deem it appropriate, but deny in part to not grant the exclusion of small company or related similes. Okay. Which one's next? 40. Okay.
Your Honor, this one may take the time. Do you want to do a break or do you want to go forward?
Let's do this one now. Then maybe break after this one. Oh, yeah. This is the one I'm inclined to rule against you on, right? Okay.
I will give you the heads up.
Take the lesson from your colleague.
Of course, Your Honor.
Dr. Clark.
Can I start, Your Honor?
Yeah.
So, Your Honor, what I wanted to do first, one, to conserve time and one, to address what I thought the court's main issue was, is the chronology. I want to get that straight right now. The initial expert report was due October 8th, 2025. It's our position that the photo micrographs should have been provided then. The rebuttal expert disclosure deadline was October 29th, 2025. Certainly should have been provided then, but I still believe it's initial expert opinions based upon photo micrographs. The deposition of Dr. Robin was taken November 14th. So now we have both deadlines passed. Deposition is scheduled and taken November 14th. That was a Friday, Your Honor. That Monday, our corresponding expert, plaintiff's corresponding expert, was taken, the 17th. After that deposition, approximately two hours after that, that's when the photo micrographs were discovered. When I say discovered, when we were able to get them from HOLO, which is the document depository. So I wanted to make that clear. The other thing I wanted to make clear, Your Honor, before I reserve for rebuttal, is there's no good cause shown. So we have a special master order providing the deadlines. The court, of course, approved that order, so it became an order of the court. The defendants missed both deadlines, and then I think tactically decided to provide it after the depositions. What we do know
I
from
guess that might beg a question that maybe I didn't think of, and maybe it's in the briefs and I just missed it, but do we know when the photo micrographs were taken?
What we do know from, the straight answer is, Your Honor, I don't know the date, but what I can tell you based upon the deposition is that Dr. Robbins said that he sent the roughly 12 micrographs to counsel, believing that will be part of the report and provided to us. That's what he says in his deposition, page 55, lines 11 through 16. So what we do know, simply applying the rules, Your Honor, Rule 16 and Rule 37, if you fail to produce, then Rule 37 I guess it determines the extent of the repercussions, which is the exclusion of that information. So that's what we know. I wanted to give you the chronology so you can put everything into context and let you know that if you review their opposition, there's no good cause shown. And I'll save the rest for rebuttal.
Thank you.
Thank you.
Tyler Watson for Real Water, Your Honor. So I wanted to go back to what you originally articulated at the beginning of today's hearing. You are correct that photomicrographs are microscopic images of liver tissue slides. That's all they are. It's a zoomed in picture of evidence that was in plaintiff's possession. These were the liver biopsy slides from the acute illness phase of Mr. Parent and Mr. Sharapov's illness. As a part of this litigation, plaintiff directly obtained these liver tissue samples. They gave those liver tissue samples to their pathologist, Dr. Datnow. Thereafter, Dr. Datnow provided the samples to Dr. Robin, the defense pathologist, and he took some zoomed in pictures of the information that had always been in plaintiff's possession. It's not new evidence. It's nothing that was ever deprived of the plaintiffs in any way, shape, or form. In other words, Dr. Robin's report was not based on anything that Dr. Datnow did not possess at the time he authored his initial or rebuttal report. Dr. Robin merely took some close-up snapshots of the liver tissue issue slides he got from Dr. Datnow. Notwithstanding, his opinion wasn't based on those zoomed in slides. They were based on the actual pathology slides in their entirety, which we cite to in page 8 of our opposition. His testimony is clear. He says, I've looked at the whole biopsy. I didn't take a picture of every field of view. My opinion was based on my overview of the 2 needle cores, meaning the actual biopsy slides, that were on each slide that came from Mr. Shaparov, and the 2 needle cores that came from the liver of Mr. Parent. I only took the photo micrographs of certain areas. So this isn't new information, new evidence that actually had to be disclosed at all. Tellingly, the motion doesn't cite to a single statute, any case law, or any authority of any kind whatsoever to support their request for the exclusion of Dr. Robin's entire testimony at the time of trial. Pursuant to EDCR 2.20, this court should deny the motion because the request is unsupported in any way. Also, as articulated previously, there is no prejudice. The images were supplemented within the discovery period as soon as the issue became discovered. Plaintiff had ample opportunity to have Dr. Datnow supplement his report or to request a supplemental deposition of Dr. Robin if it was needed. It wasn't, and that's why they never requested it. Essentially what happened, Your Honor, is that Dr. Robin sent a report under one email and sent the photomicrographs under a separate email, not understanding in our office that those were actually zoomed in pictures as opposed to the actual full path slides. They weren't disclosed. When it became apparent during his deposition that he wanted them disclosed and that there were questions, within 2 hours of his deposition concluding, a supplemental 16.1 went out. And again, it's not new evidence. It's just zoomed in evidence that plaintiffs already possessed. So unless the court has any additional questions.
No questions. Thank you.
Thank you, Your Honor.
Your Honor, I would rather you rely on the doctor's own sworn testimony than mine or Mr. Watson's. If you could, Shane, I actually want you to start with page 54 of his deposition, line 16 through 25. This is a deposition of Dr. Robin, Your Honor. Mr. Kemp asked Dr. Robin, you could make that larger because I don't know if anybody in the room, anybody over 40 can actually see what that says.
I can see that.
Now,
Yeah, that's
there we go. So the question is, okay, so you made different fields of view in order to depict there was bridging fibrosis or less bridging fibrosis. Is that what I'm hearing? Yes, that's correct, Mr. Kemp. It was to show that the bridging fibrosis was focal and it was mild and wasn't observed either by a hospital pathologist or the Loma Linda pathologist, nor is it stated in the Burke article. So 3 pathologists, including Dr. Robin, did not see. Now, the point is different. This is not something you can do with your iPhone, Your Honor. This is something that requires a heightened level of microscopic investigation. That's the difference. If you were to simply follow Mr. Watson's lead, you would think that someone just had to pull the picture a little closer to them. That's not it. It takes a machine, a piece of equipment to get this level of micrographs. Now, this Dr. Robin says further in his deposition, if you could go now to page 58, lines 5 through 15. Thank you. Again, Mr. Kemp, if you had just had Dr. Datnow's slides where you said it was focal and you did not have the photo micrographs that you made, would you be able to say that it's mild? Answer, well, no. Period. That is the answer to this motion. Without the photo micrographs that he made, which are used in support of his opinions, which under Rule 16, we're entitled to have all support for his opinions, he would not be able to give the opinion that Regal Water would have and bring before this court.
So
And
how
then-
do you address, I mean, the slides you all had, right?
Not the photo micrographs. But yes, you're
So
right.
you're playing the attorney of not answering my question.
No, you're right, Sean.
Okay, I mean, I understand you can't do it with an iPhone, but their photographs, I mean, maybe we call them a reproduction, I don't know, photo micrographs,
There's photo micrographs, that's
Yeah.
correct, Sean.
of evidence you all had in your possession. I mean, it's not new evidence, it's just another view. And so, for example, you know, we have different medical images sometimes that, you know, somebody hasn't actually really fully looked at, and you have to put in front of a jury, even at the time of trial, and some other view. I mean, how is that different than what we have here?
I appreciate that, Your Honor, and it allows me to develop this part of the record. Your Honor, if our expert had actually done photo micrographs, we would have produced them. That's the point. And you hit the nail on the head. For example, if this was a back injury case, and all we had was x-rays, but then someone went out and did an MRI, we'd have to produce the MRI. Now, it's the same back, but it's a different way of looking at the back. This is a different way of looking at slides. It's a technique. It's a medical technique. It's something used by pathologists. And as soon as they introduced photo micrographs, they should have produced it. But you know something? Dr. Robin knew this. I want you to see this, Your Honor, page 65, lines 14 through 22. This is how you know even the doctor knew. It says here, Your Honor, and you sent it to Mr. Watson with the understanding that he was going to put it in the report. Yes. And the same would be true for Mr. Perrins. Yes. The micrographs of both Shaparov and Perrins were supposed to be in the report. And you've heard no good cause yet why it wasn't in the initial report, why it wasn't in the rebuttal report. Your Honor, it shouldn't take a deposition roughly 3 days before the end of discovery, after deposition that is, for documents used to formulate opinions to be disclosed. And that's what it came down to. And when he said he would not be able to give these opinions without the photo micrographs, that triggers 16.1, and that's it. So let's say that we had done the photo micrographs. Certainly, we would have to identify that as a part of the support for our experts' opinions. And these photomicrographs, not just the pathology slides that we gave them, is what forms his opinion. Now, if he said, listen, I just looked at the original slides and this is my opinion, I would have nothing to say. But as soon as he did something else with a piece of equipment, bringing a higher degree of magnification, and he's using that to support his opinion, under Rule 16.1, you're supposed to provide it. And Rule 37 says it's self-executing. If you don't provide it, you can't use it. So that's what we're asking you, unless the court has any questions.
No questions. Going to stick with my initial inclination, deny plaintiff's motion limiting number 40. For the reasons articulating the opposition, include but not limited to, I'm gonna give you some thoughts. I mean, they're taken from a slide that was in plaintiff's possession. Yeah, I agree. They should have been produced with the initial report. I mean, that's clear, at the very least, the rebuttal. Now, having said that, there is sufficient cause or excusable neglect for the lack. We have you can redepose them if you want to.
That's fine. We'll meet and confer on that.
We have an accelerated discovery timeline in terms of a complex large case. Now, I'm not saying that it's wrong, because I've approved it. I stick with that, certainly. But the fact that there may have been, something like this inadvertently missed is understandable. The relief sought is certainly overly drastic in terms of precluding the doctor from testifying regarding the degree of injury. That relief is I'll leave it to defense to think of a better phrase, but way too drastic for what happened here. There is no harm or prejudice with the ability to, if plaintiff so desired, to redepose them on a limited basis. Appreciate the X-ray versus MRI analogy, but that's a totally distinguishable analogy than what we're dealing with here. Let's see. Yeah. So denied for all those reasons. Thank you. Right. 42. Okay. You might have to fill me in on some of the details other than the quote that I wrote down, but you want to defer.
Your Honor, we'll reserve on this.
Oh, okay, great. Tyler Watson again for Real Water, Your Honor. So the issue here is the Batts-Ludwig scoring for liver fibrosis. Batts-Ludwig, by both pathologists, agree that it was validated for hepatitis, specifically Hep B and Hep C, and drug-induced liver injury was not what Batts-Ludwig was originally validated for, and it never has been. Again, both.
But doesn't everybody use it for that? I mean, everybody, including him?
Yes, so that's a good point. I'll cut to the core of the issue. So essentially what Dr. Robin explained in his deposition was that because it was designed for hepatitis, which usually occurs over a more prolonged period of time, it creates more uniformity in the liver fibrosis. He thinks that hydrazine exposure, due to the fact that it's acute, creates a different pattern of fibrosis, and he just doesn't believe, absent the validation and the lack of uniformity in scarring, that it's the appropriate tool to use to rate the level of fibrosis. Ultimately, he thinks the absence of validation in conjunction with his opinion that hepatitis and drug-induced liver injuries create different patterns, that it's not a reliable tool here. He has previously used it. He agrees that pathologists often use it. he's not coming in to say that there's no fibrosis. He's simply saying, I'm using a different scale because I think it's more appropriate here. Having spent more time with the issue, he thinks it's a better scale, the one that he's using. He's not saying that Dr. Datnow can't, and they certainly are able to cross-examine him on his use of a different scale for determining the level of fibrosis. But the idea that he can't come in and say, yeah, because it's never been validated, I'm using a different scale. I don't think that's an appropriate response. I just really think it goes to weight. And again, they can certainly point out to him, as they did in his deposition, that he's used it before, and he can explain why he's changed his opinion.
Why, and this might be one of those things that's in the briefs, but, if, okay, I say, okay, well, you know, he's not precluded from using a different scale as you're suggesting. Does he have sufficient foundation, to be able to use this other scale?
I believe so, Your Honor. He articulated the reason why, as we discussed, that he thinks the patterns are distinguishable between DILI and hepatitis. And the other scale is a more accurate representation. It's broader. I think that scale goes to 5 as opposed to 4. So you can slice it a little bit more finely. But ultimately, he's not going to come in and testify that either of these individuals don't have fibrosis. He's just choosing a different scale. That's all. Thank you, Your Honor.
Thank you.
Your Honor, I'll be equally brief. You caught this one early on. I think you started today's discussion with, we sometimes get smarter with age. And that was Dr. Robbins' comment being questioned by Mr. Kemp as to why he decided to change the approach, the use of the
I
bats.
think you mean, do you mean, Dr.? Oh, is it? I'm sorry. Go ahead, sorry.
No worries, Your Honor. And Your Honor, we cite this in the brief. And you read it or said it earlier today. But this has been used throughout the last 40 years, I believe. And it was used by, we cite 3 articles to talk about how often it's used and how this is the gold standard in terms of evaluating fibrosis. Dr. Robin used it beforehand. He used it in the last case, Your Honor. Loma Linda used it. Everyone uses it. I believe he's trying to now use this ISHTAC approach in an attempt to minimize the level of fibrosis, which he has no support, and it's just not in the briefing. It's not, and in fact, it's not in the articles. The articles that are cited all support the use of the Batts-Ludwig approach. Your Honor, we identified all of the time, and it's been used in all of the other cases, Your Honor, as well, that the Batts-Ludwig approach has been referenced as determining the level of fibrosis. In fact, more than 80% of pathologists and clinicians use the Batts-Ludwig system. So for Dr. Robin to come in and suggest that it's not the appropriate standard, it's not the gold standard, which has caused confusion, it's prejudicial, Your Honor, and is not supported by the medicine in this case.
Thank you very much.
Thank you.
So the court grants plaintiff's motion limine number 42 for the reasons articulated in motion and reply. Confusion, lack of foundation. Those are 2 of the reasons, but they're better articulated in the motion replies, include those in the order. All right. Next. Oh, yeah, we're gonna take a break, right? Yes. Let's go back 20 to 3.
That you were inclined to grant in part, and then you said, but you welcome argument. That's what my notes said.
I have welcome arguments, grant part / deny in part, question mark.
That's what I did.
Okay.
So Your Honor, let's see if I can at least, I would think, answer some of the obvious questions. I had the pleasure of taking Mr. Perdue's deposition, and apparently this was his first foray into punitive damages. which I guess everyone has a first. But he had no experience in analyzing a case or an industry for purposes of punitive damages. So I asked him what litigation experience he has. His litigation experience was only in terms of evaluating a business for purposes of contract claims, not for litigation punitive damage claims. So I asked him, how did you come up with your figures, Your Honor? And that's when I found out that he did not monetize many of the incentives that he wanted to introduce as a part of his punitive damage analysis, which has no support. So I asked him, well, how did you come up with these figures? And I specifically asked, you talk about certain harms that could be used as a part of your analysis. I said, did you monetize those harms, like customer base, brand identification? He said no. And that we cited to this in the motion as well as in the reply, Your Honor. But the biggest problem I had with his opinion was his attempt to artificially create this subset of a market. And I asked him, where'd you get any support for that? He said, well, he read from a trade association subsets of markets. I said, well, this is an industry we're looking at, and it's based upon the FDA's report and the FDA regulations dealing with the water bottle industry and food, the act, the actual federal regulation dealing with this, the FDA Act, Your Honor. And he said that he had not considered it in that light, only based upon what literature he read as a part of being assigned this project, that he came up with this subset. So what he did was, instead of looking at the bottled water industry, he went to the alkaline bottled water industry. And then he took a subset of that and said, well, let's look at the small producers of alkaline bottled water and determine that would be the subset that would make the most sense for him. Your Honor, there's no support for that whatsoever. So then I asked him, in terms of the trade association that you looked at, was that analysis based on punitive damages? He said no. I said, so you have no support for this subset of a subset? He said no, nothing, Your Honor. So, Your Honor, to cite the case law, it doesn't work under Hallmark. It doesn't work under Morsicato. It doesn't work under Williams versus the Judicial District Court. And for that reason, Your Honor, I think the court's inclination, at least in part, to grant is appropriate. I don't know what would be left from his opinions once you consider the case law, Your Honor. And I'll reserve the remainder of my time on thought. Thank you. Thank you.
Good afternoon, Your Honor. Marta Dunning on behalf of Rio Water. Now, before I address the points that opposing counsel made, something that I want to begin with is the title of the motion does talk about excluding specific or seeking to exclude specific opinions, but looking into both the motion and the reply, that doesn't seem the case. It seems more so that we're dealing with the exclusion of Mr. Perdue as a whole, both his opinions and his testimony. That is the premise that I'm going to be arguing upon unless the court disagrees.
No, go ahead.
Thank you very much. Now, I will not belabor the points that have been very clearly briefed here, specifically for the qualifications. What I would like to point out, however, is that on this motion, we're dealing with admissibility. We're not dealing with the weight of the testimony or of the opinions. And Nevada law has clearly established that the weight of the evidence must be evaluated by the jury, and specifically any specialization that, for example, the expert witness has to have. All of those are evaluations that go to the weight. An expert witness needs to have general qualifications, which Mr. Perdue does have. The very narrowly specific qualifications that opposing counsel is arguing in favor are actually not something that Hallmark allows for. And this court is very well aware. We're looking at, again, this comes from Hallmark, general qualifications. Mr. Perdue is a financial analyst. He has both a financial background from his education. He has an MBA. He has numerous financial analytics related certifications.
So on, in terms of his qualifications, from what you're just saying about his qualifications, what qualifications does he have then to decide, okay, well, I'm not going to look at the water, I forget, water bottle market. I'm not going to look at the beverage market. I'm going to hone in only on the alkaline water market. And then plaintiffs argue, although this wasn't super clear to me, they argue that he doesn't even use that market. He uses a subset of the alkaline water market. What qualifies him to come to the conclusion that that is the market he should look at?
Thank you, Your Honor. In addressing that specifically, financial analytics is obviously a very big area of expertise. What the expert did here is use all of that background knowledge to then do specific research into this industry and into punitive damages. He has a general understanding of punitive damages, and they're very well articulated in the report itself. And I have not heard any dispute from opposing counsel regarding whether his understanding of punitive damages is correct. What we're seeing in the report specifically, and I will direct your attention to the relevant market portion of it, which begins on page 8. Mr. Perdue started with a large overview of the bottled water industry. He then evaluated, he looked into the 29 soft beverage companies, and can be seen on page 8. He then looked at the 11 that produced different brands of bottled water, and then trickled down to what he then, after performing all of this analysis from the companies that produced bottled water, how many produced alkaline bottled water, coming to the conclusion that what we're looking at for the purposes of punitive damages in this case has to be narrowed down to the alkaline bottled water industry, because real water, that is the product that we're looking into. That is the product that is the one that's alleged to have contained hydrazine and harm people. So he was going off of the facts of the case and tailoring the punitive damages analysis to that. Now, I am hearing the argument regarding the statute and the strict liability statute and the FDA and what those regulatory bodies are looking at. But what I think is lost here is the distinction between a market analysis and a regulatory framework. And a market analysis, again, from a financial analysis standpoint, and what the legislature did when creating the strict liability statute. We're not asking Mr. Perdue to provide a legal opinion on strict products liability. We're asking him to provide a financial analysis of punitive damages here, for which he needs a very specific economics-based and market-based analysis that, of course, is going to differ from the regulatory framework of the FDA and whatever different states have codified in their statutes. Did that answer your question, Your Honor?
That's a good question. I'm not sure it did, but you did respond to the question.
No, something else that opposing counsel mentioned is that that Mr. Perdue did not monetize the incentives. What opposing counsel is referring to here is specifically the deterrence section that starts on page 15 of Mr. Perdue's report. It's PLTFS 000171. Now, what Mr. Purdue has done here is he has gone through several recalls that some of them have caused deaths in children and other and adults and have injured countless others. And what has pretty much happened to each and every one of those companies is an example. And he does quantify the Perrier had a 75% reduction in earnings, that for another company, their industry-wide sales were down by 25%. And with that, he does conclude in paragraph 56 regarding exactly what those economic incentives do as a deterrent in the industry. Now, the issue with not monetizing those particular incentives does not actually is not a basis for exclusion on its own, because then there is a whole section regarding the punitive damages deterrence here, and then another one regarding the punitive damages range. All of those are quantified. And lastly, the point here is both the motion and the reply and opposing counsel's argument, they point out specific disagreements with the methodology. But that all of that goes to the weight. We can be here for another 45 minutes, maybe an hour and a half, if we're going to go through each and every one of them. And to be honest, Your Honor, when I was going over this weekend, I had to tap into my economics background from college, and it's been a very long time. So while I would be happy to address those, I doubt that that's the point of the appearance today. But with that being said, again, we're here to talk about admissibility under Hallmark, not the weight of the evidence. We've got our expert that explains why he did things in a certain way, and then they've got Mr. Mark Rich to explain his approach to this and why he disagrees. But again, all of that has to go to the jury. To exclude our expert witness would pretty much leave plaintiffs with an expert witness on punitive damages that is unrebutted, uncontested, and that would be exceptionally prejudicial to Rio Water. If there are any specific questions that the court would like me to address, I will be happy to.
No, thank you very much.
Thank you, Your Honor.
Your Honor, I can understand and appreciate the Rio Water's position on not having an expert, potentially. In the other prior cases, experts weren't called on the defense, 5 trials, and they failed to provide an expert or actually designate an expert who has experience in punitive damages. That was Rio Water's decision. Your Honor, the opposing counsel seems to suggest that because of the prejudice, they should be allowed to put confusing, unfactually and foundationally unsupported opinions in front of the jury. That's exactly what Hallmark stands against. And in fact, Hallmark, as well as NRS 50.275, says that the expert must have special knowledge, skill, experience, training, and education to assist the jury. Your Honor, there is no legal or factual support for what this expert did. And in fact, I spent a couple hours deposing this expert, trying to find the foundation for his opinions and trying to figure out what supported the submarket of the submarket. The industry is what the FDA, the CDC, and the Southern Nevada Health District examined and applied regulations addressing the food and beverage industry. What we've done, and this is what happened in front of Your Honor in the Brown and the Wren case, is that we narrowed it only to the bottled water industry, which is what 9 of the FDA findings were against Rio Water. One of which involved failure to test before the product, failure to test after the complaints, failure to investigate. All of those things, you remember those things, I'm sure, Your Honor. And so when I deposed Mr. Purdue, I asked him, did you consider any of those things in determining deterrence? He said no. Not whatsoever. The only thing he said he considered is that the E2 concentrate led to hydrazine formation. And so he tried to find another bottling company or water company that had that approach. I said, that's one of many things. I said, did you consider a deterrent effect just related to the one business? Well, he said, no, I was trying to find a subset. I said, well, what support do you have for that? And his only sole support was a trade association that talked about markets. And he used that, and then he admitted that trade association analysis of markets had nothing to do with analyzing punitive damages. So I said, do you have any other support or foundation for your opinion? That was it. So then I tried to discuss with him, what are you trying to deter? Because if you've not looked at the financials, which we're intending to use deterrence as the basis of our punitive damage award, I said, what did you determine or analyze for deterrence? He said, well, brand, loyalty, harm to customers. I said, well, did you put a dollar figure on any of those? He said, no, none whatsoever. So then I asked him, Your Honor, well, what else could you have used? He said, well, I could have used profits. I said, well, does profits go to deterrence? He said, no. Your Honor, there is nothing there's no methodology, which you're familiar with Hallmark, and it says it has to be the product of reliable methodology, which means an analysis based on foundation, numbers, an industry that we can look at. He didn't provide us anything we could look at, nothing that will assist this jury, certainly, because he can't put in front of the jury. This is a trade association document that I looked at that talked about submarkets. And Your Honor, the other thing I asked him, which you may find persuasive as well, I said, if you decided to go on this submarket of a submarket as opposed to the industry, which is being regulated by the FDA, did this submarket of the submarket, which he went from bottled water industry to alkaline bottled water industry to small producers of alkaline, that's the market of the submarket. I said, do any of those have a failure to investigate, inspect, the E2 concentrate or anything like that? He didn't know. So Your Honor, there's no basis for him even going to the submarket of the submarket for purposes of his opinion. The other thing that
Remind me, did he, my memory may or may not be on point here, but pause their time while I try thinking. Is this one, is vast majority of this binder.
you only had 150 look at, Your Honor. Don't be too hard on yourself.
This is going to be way more vague than I would like it to be, because I would like to be much more specific in my question, but was there a point where he essentially used a percentage of what your site calls the industry that was similar to what Mr. Rich did, but he said that was inappropriate, or am I totally kidding?
No, you're right. You're right. Towards the end of his deposition, I asked him, I said, if you were to use the industry, which is what the FDA did in terms of its regulation and citing real water, would your numbers be different? And he said, well, if I use the industry, the number was multiples of it. I think he said 255 billion, where our expert, I think, was somewhere around 280 billion. I said, but you chose not to do that for whatever reason. But you're right. And I said, if you were to multiply that by the percentage that you tried to use for purposes of a subset of a subset, what would the number be? And then he came up with some number near $14 billion. But Your Honor, that's exactly what happened during the deposition. But for some reason, he artificially created these submarkets without any foundation for it. But you're right, that's what happened towards the end of that deposition, Your Honor. The other thing I asked him, I said, this is going back to the FDA. This may also bring some clarification to my confusion with his responses. I asked him, the FDA documents, would you agree that it did not cite to a regulation that only pertains to alkaline bottled water? And there's an objection. He says, I don't know. If we want to look at the document, we can pull it up and look at it. I go further. Understood, but the regulation being cited by the FDA was not a regulation that only pertains to alkaline bottled water, correct? Again, I'm not a regulatory lawyer. I'm not going to weigh in on that. Despite me trying to get him to even answer the question, he says he's not a regulatory lawyer, but then he comes up with artificial reasons to come up with this subset of the subset, Your Honor. This does not assist the jury. It's not in conformance with Hallmark or Williams or 50.275, Your Honor. I don't know what he can afford the jury. The other thing I wanted to mention, Your Honor, is he tries to suggest that a market, when he uses the word market as opposed to industry, the market includes the consumer. So I said, well, how can you punish the consumer if the consumer is part of the market? And then he said, well, I have different feelings about the consumer market involving the retailers and the distributors. I said, well, under NRS 41.141, there's joint and several. And he said, well, I don't see it that way. So despite him not being a regulatory lawyer, he wants to, in effect, create jury nullification by introducing a separation of the consumer, then the retailer, then the distributor. Your Honor, again, that goes against our laws, our statutory law. And then finally, Your Honor, when I asked him about deterrence, of course, going to Ace Trucking and our punitive damage case law in the state, I said, do you understand there is a difference between punishment? And he says, he was conflating. He said, well, the punishment I'm trying to address also is, again, the loss of brand and the loss of customers. I said, but how is that internally actually giving us an analysis deterring others from committing all of these mistakes? And he had no answer for that, Sean. And so that's generally his testimony, and it's different than what opposing counsel has said. But that type of testimony, the court being a gatekeeper, it doesn't assist the jury, and it's not in conformance with our case law.
Thank you very much. Let me turn back to the motion here. Yeah, so one of my notes that I wrote in preparation, concerns. So when I say concerns, my concerns regarding his the lack of competent evidence / foundation for his opinions. So that remains, and that's a foundational type of concern. So the court grants latest motion limiting number. It's not numbered on the title, but we call it 44. To strike or preclude certain opinions of defendant's expert Glenn Perdue for the reasons articulated in motion or reply. I'm going to touch on some of them. One of which I just said, is foundation is lacking in terms of the evidentiary competent evidence basis for his opinions. He also, to be clear, I'm sure he's a fine expert in these other types of cases that he's testified to. But this is a particular type of case which he does not have qualifications to testify here. He also, again, the foundational basis and the analogy from Hallmark to the accident reconstruction expert, that's a fair analogy for all the reasons set forth in plaintiff's briefs. He lacks the requisite qualifications, plus you know, he doesn't have the competent evidentiary basis or the opinions that he's purporting to provide. Motion and reply are much more detailed than that, so put the reasons in there as well. But this is essentially to find a guy who has some background and expertise in what he does, but it doesn't have anything to do with what we're dealing with here. So granted for those reasons. Thank you. Next. Inclined to deny, can't, oh, this is the one where I had a hard time following plaintiff's briefs based on the exhibit that was attached.
Your Honor,
Oh, is this moot?
I think this is moot, Your Honor.
Okay, okay, sorry. So that's moot, given the what I just did, granting the other motion. Okay, next. Yeah. Nevada Beverages motion limited number 1.
Yes, Your Honor, that one's next.
Okay. Inclined to grant that one, but what claims? You want to reserve?
Yeah, Your Honor, I'm sorry, Jake said he will be arguing this motion, but we'll reserve.
Sure.
Thank you.
So Your Honor, on this one, in your inclination, you mentioned that the evidence that they were seeking to pre-admit was, you thought that it was referenced by the defendants. And so I had this one down as a clarification because number one, in terms of the motion that was actually filed, well, let me take a step back and say where we're at here. You know, this is a motion to pre-admit. It was filed by Nevada Beverage. Nevada Beverage is settled. Now, apparently the other defendants have taken up the mantle on this, and they're seeking to pre-admit evidence that Nevada Beverage employees consumed real water for years without issue. And so we got the motion, and Shane, if you could put up page 5, I'm sorry, page 6 of the motion. In terms of what they identified in the motion, lines 6 through 8 is it. Robbie Gallegos, Kenneth Rathall, Michael Marsh, and other NevBev employees who were never identified supposedly consumed substantial amounts of the same retail product allegedly consumed by the plaintiffs in this case in the same time period, but without getting ill. So that's it. That's the evidence they identified in the motion. And in our opposition, we come back and say, well, look, this isn't specific in terms of what you're seeking to pre-admit. And how can you establish the relevance, the foundation, the accuracy of this without citing the actual testimony that they seek to admit or evidence that they seek to pre-admit?
Reply, they block quote. Is that what you're gonna say?
Well, certainly in the reply, they come back and they add some testimony in there, but that's in the reply. I mean, that's not in the motion for us to address, and that's problematic because even though they did not attach the testimony or evidence that they're seeking to pre-admit by their motion, what is cited is a CDC presentation on the Southern Nevada Health District outbreak investigation. That's exhibit C to their motion. And a couple things that are interesting about this, Your Honor. Number one is we actually moved to pre-admit this same presentation. That was our motion to eliminate 47. Defendants opposed it, and that motion was actually denied. Your Honor declined to pre-admit this evidence, saying, well, I'm not saying it's not going to come in, but you got to lay the proper foundation. And so I find it, ironic that they're citing the same evidence that they opposed pre-admission on to try to get pre-admission on this. But importantly, the CDC presentation, Shane, if we could go to page 481, Exhibit C, it discusses a household severity study of the real water in consumers that they identified within the narrow window that the Southern Nevada Health District investigated. And what this pie chart is basically saying is of the households, they're all drinking real water. 44% of them were hospitalized. 8 of them, 25%, had no symptoms that they observed amongst themselves, and another 33% had symptoms that didn't require hospitalization, such as nausea, vomiting, diarrhea, things like that. And we kind of say in our motion, and the evidence is out there, is not everyone responds the same way to hydrazine in real water. They drink different amounts over different periods of time, and they're different weights and sizes, and ultimately, the biggest factor that we believe is, a lot of people have this enzyme, which makes them, it affects how you metabolize hydrazine.
I read that motion today.
Yes, and that's called a slow acetylator. Also, they're trying to exclude evidence of this. And really that has a pretty big impact on how you're going to react to hydrazine, because if you're a slow acetylator, it's in your liver longer.
Let's go back. Let's say they did block quote in the reply portions of the deposition testimony. What issues, if any, do you have with that specific testimony?
Yes, Your Honor. And I think that goes to my second point, which is relevance. So what they're trying to do to pre-admit this is they're trying to hold it out as some sort of relevance to causation. Basically, they're drawing making a logical leap that because not everyone who drank real water got the same level of liver damage, that means there's evidence that real water didn't have hydrazine in it or didn't cause the individual plaintiffs.
But even the exhibit you want pre-admitted, which apparently I disagree with, but even the exhibit you just pointed me to that you wanted in evidence makes that point, right?
Yeah, well, yes, Your Honor. I think the point is that not everyone who drinks real water is going to get the same severity of illness or even any illness at all. And there are reasons for that. And, just because someone drinks real water and doesn't get sick, it doesn't mean that there's no problem with any other real water. And so that's what we think is a relevant issue. And what they're trying to argue is say, well, look, we know people who drink real water and they say they didn't get sick at all. So therefore, real water doesn't make people sick. That's what they're trying to pre-admit this evidence for. And that's why we say, look, it's not relevant. Even if you did identify it, even if, you could specify what you're seeking to pre-admit, which they didn't do. It's not the fact that some people drank it and didn't get sick or didn't know that they got sick from it is totally irrelevant to any issue. And even if it had some marginal relevance, the probative value would be substantially outweighed by the danger of unfair prejudice, confusion of the issues. And that's borne out when they cite the actual testimony in the reply. For example, they cite Mr. Gallego's deposition, and they're asking him, so are you drinking it consistently from the end of 2012 to 2013 until 2021? No, it wasn't my only choice of water, but in the gym in the morning, yes, 3 to 4 days a week when I was going, which I haven't gone in a while.
I've got it. You should save your time rather than reading a block quote would be my suggestion.
Fair enough, Your Honor. I appreciate that. So the bottom line is it's not relevant. It's unfairly prejudicial. There are lots of reasons why someone may drink real water and not get sick, or they may not know it. They don't have the foundation to know if they got nausea or vomiting at one point, whether that was because of the real water they were drinking. That's a general symptom. It just introduces irrelevant issues that are more prejudicial than probative, and we'd ask Your Honor to reconsider the pre-admission. If somehow this becomes relevant, and they can lay the proper foundation, they're not precluded, but pre-admission, Your Honor, we'd ask be denied.
Thank you very much. Are you okay if I grant it limited to the block quotes from the depositions, and or should I pre-admit exhibit C as well?
I'm fine with to the block quotes, Your Honor.
About exhibit C that you're relying on that apparently I did not allow yet into evidence. Exhibit C is the CDC PowerPoint kind of presentation.
Can I have an indulgence to confer?
Sure.
Wasn't that on our pre-trial memo set?
Well, it was what we wanted to have in the first
No,
place.
But it was part of motion before.
I think it's, are you sure it's not in the pre-trial memo? Because I thought we did that after the fact. Sorry, Your Honor, I apologize for the court's indulgence. I think we can.
Okay.
We're working through pre-trial memo stipulations.
Oh, at the same time, gotcha. Okay.
Too many moving parts, yeah.
Well, I'm gonna save some time.
We would, let me just.
Okay. C is pre-admitted, but also pre-admitted is the deposition testimony is block quoted. Page 4, page 5, page 6 of the reply. To the extent there's more sought, it's denied. Of course, that's without prejudice. But yeah, the block quotes are, and they are relevant, and especially given what other evidence I've already allowed. I mean, this makes perfect sense. That's granted.
Thank you, Your Honor.
Which one?
Number 2.
2. Inclined to grant this one too. Do you want to save for rebuttal? Okay.
Your Honor, on this one, again, we're talking about pre-admission, and what they're asking to pre-admit in the motion is I believe it's on page 7 of the Nevada beverage motion. So they reference pre-admitting the, and Shane, I don't know if it's easy to pull up Nevada beverage milk to page 7. It has all the units of purportedly sold in 2016, 2017, 2018, 19, and 20. I don't know how we can pre-admit this as evidence when they have not identified any foundation for these numbers. There's no business records, there's no documents, there's stated amounts in a motion. It is unclear where these numbers come from. They cite,
yeah, go ahead. Go ahead.
They cite to a deposition of Michael Marsh, which page 33 and 34 of the deposition, which is exhibit A to the motion, Shane. And here, Mr. Marsh is just saying he's essentially estimating the number of pallets per week. He specifically states on page 34 of his deposition that he was the inventory manager from sometime in mid 2017, from 2017-ish to 2021. They cite in a footnote that the court can take judicial notice of arithmetic, but I don't know how you take his kind of general testimony about estimates on pallets and come up with the numbers that they're seeking to pre-admit in the motion. So again, Your Honor, I think if there's some relevance to this, which I disagree with, but if they establish relevance or you find it relevant,
Limit it to the actual testimony.
or Your Honor, I think they need to present lay some sort of foundation at trial to present evidence of this, just to state these numbers in a motion and cite vague testimony. I just don't know how that's enough to lay a proper foundation.
Thank you.
Morning, Your Honor, or good afternoon, Your Honor, how are you? All right, so should I address the relevance of this data first? or
No,
how'd you like me to
it's
go?
certainly relevant and, fair, given the other evidence that I've allowed to come in pre-admission wise. My only question, I guess, really is, the lawyer joke. I went to law school, there wasn't math. Looking at the deposition and your numbers, I'm not sure I can say, okay, judicial notice of your calculations based on the testimony, but if you're okay with just, maybe you can, write them on the board in front of the jury and do the calculations from that testimony. But that's my one concern is the numbers aren't actually in this transcript.
Yeah, I think that's fair, Your Honor, not forcing you to take judicial notice of it, but being able to put it in front of the jury on a whiteboard, or so to speak, I think that's very fair.
Okay, so grand part, so not the units sold, those aren't pre-admitted, but the testimony there on Mr. Marsh's deposition, pages 33, line 18 through 34, line 15, admitted. Yeah, we'll see if you can pencil it out, so to speak, in front of the jury and get those numbers in front of them. But certainly the testimony and the numbers he gives in that testimony is pretty many. Okay.
Your Honor, can I ask one clarification on this? Is pre-admitted in the sense that they can call Mr. Marsh and present this testimony?
Well, that's a fair question. So I don't, there may or may not be an issue with Mr. Marsh appearing live or over Zoom. So pre-admitting is, whether he comes here live or over Zoom, they can play that deposition transcript portion in front of the jury. Does that answer your question?
Yes, Your Honor, thank you.
3.
Your Honor, Jim Cavanaugh for Terrible Herbst, ETT1 DBA Terrible Herbst. We'll reserve on 3 and then.
So I think I'm inclined. What did I?
denied, so.
That's what I was gonna say.
Well, then maybe I misunderstood. I was looking for clarification.
My
but,
note,
I had heard.
did everybody else think I was inclined to deny it?
Your Honor.
Because sometimes I don't go by my note.
Well, then maybe I shouldn't.
Yeah, so let me say, I think I said deny, and correct me if I'm wrong, but I think that's what I was inclined to do. And if I didn't add, this seems to be a question by question, answer by answer type of what's asked for is way too overly broad. Better handled with actual specific objections at the time of trial was what I would say. So if I were you, I wouldn't reserve because I'm inclined to deny it. So,
Okay, so I'd like to come up and speak
Sure,
with you,
sure.
Your Honor, if you don't mind.
sure.
I guess it was the question by question, answer by answer, and so Terrible's joined Nevada Beverages motion in limine number 3. And it's also related to 21, but I'd like to address that separately. It's the second part of the motion that I focused on and would like the court to see as maybe an area to clarify better and understand our position. And that is, so the way the motion reads, Nevada Beverage Motion Limine number 3, to exclude evidence of hydrazine test results and speculative expert opinions about it. And it's that second part that I believe I would like to address with the court and maybe get a little better clarification. It would seem to me that regardless of the prior test results, it's where the rubber has thrown, so to speak, is on the way plaintiffs experts use that in their opinions. And because it's often been said here that the defendant's experts didn't do any testing. None of the experts in this case did any testing.
Oh,
of the
so
real
you
water.
could say plaintiffs experts didn't do it.
That's right.
Okay.
They did not. They absolutely did not. And so opinions about the test results by any of the experts may end up being a stretch beyond their hallmark abilities and beyond NRS 50.275. So whether or not so no expert is able to testify based on those test results and speculate about whether or not Milo Herbst consumed any amount of that water, however adulterated it might have been according to the test results, and whether or not it was enough that it injured Mr. Herbst or caused his death. It would be speculation. To further understand that, recall that all of the testing occurred after 2020, and that was 2 types of testing. You'll recall the concentrate that the 5-gallon product was made from, and later 1 liter retail bottles were tested by an independent Eurofins that one of the defendants retained to do those tests. And they tested 7 bottles and they found what some characterize as trace amounts in 4 of the bottles, notwithstanding the sample size. Those test results are what they are, and nobody can dispute those later. But what is in dispute is how an expert uses those test results to come to the conclusion that any of the plaintiffs, but I'm only here concerning Mr. Herbst's injuries and claims related to his consumption of real water. So I would just ask that the court consider, if it denies or grants the motion, you mentioned question by question, answer by answer. So we have 4 plaintiff experts at issue here, essentially. And one of them is Dr. Najim. And he doesn't know the amount of the real water adulterated that was consumed by any of the plaintiffs, and certainly not Mr. Herbst. We have the medical toxicologist for plaintiff, Dr. Michael Cosnet. He doesn't know what amount of water Mr. Herbst consumed or when he consumed it. Ultimately we have Dr. Kahn, Jeffrey Kahn, and prior to Mr. Kahn, Dr. Kahn, we had Dr. Hudson. None of them knew the lower limits that any of the plaintiffs, and that would apply equally to Mr. Herbst, could have consumed and not caused him injury. Conversely, Dr. Jeffrey Kahn, plaintiff's lead expert on causation in this case, doesn't know, could not say if consumption of real water caused injury or death to Mr. Herbst. So as to regards to your decision and consideration of Nevada Beverages motion limiting number 3, it's the second part, and it might be over broadly stated, but conversely, it should not be a basis for plaintiff to believe they have the green light to say whatever they will about those test results, which we're not disputing the test results. None of the experts, plaintiff or defendants, have done their own tests. So our medical toxicologists, you've heard about Dr. Sam Stelflug, and you've heard about Scott Tenner and Dr. Atchison. They all had opinions about the real water and causation of injury that could have come from it. So I would say that, and that's the point of my joinder to an argument for granting, if you would, some part of Nevada Beverages motion limiting number 3.
Thank you very much.
Do you have any questions for me on this one?
I don't think so.
I mean, I think Your Honor's inclination was correct. I mean, you've ruled on the same issue over and over again. All the testing and has been pre-admitted. You know, the experts can rely on the evidence and give their opinions based on the evidence. And if there's an issue with any of the testimony or evidence as it comes in, it can be handled on a question by question basis. So I think Your Honor should stick with its inclination.
Thank you. Any rebuttal?
No, Your Honor. Thank you.
Thank you. Yeah, so I'm going to stick with the initial inclination, deny without prejudice the issues raised in the motion reply. Better handle on question by question, answer by answer, objection by objection basis. You know, is detailed in the opposition essentially now. You know, yeah, it's denied without prejudice, and
Thank you, Your Honor.
thank you.
Could I address number 21 now?
Let me turn to that one.
Okay.
Yeah. I'll get that one. Still looking back through. Similar type of issue, but yes, go ahead.
With regard to Nevada Beverages motion limiting number 21, it's a bit different and related, but different. It really is. 21 is to exclude speculative opinions and testimony that real water contained hydrazine prior to December 2020. You know, we have not yet agreed upon, just over a month ago, Your Honor heard the matter on the issue preclusion motion and would probably see this as related to that, I would imagine. I can assume that. So, but here's my point here in our joinder to this motion. I won't recap again that the 2 and only 2 sets of tests ever done for real water related to all these cases that were here and have been before the courts in 8th Judicial District. I know a good part of the basis for your opinion was the finding Judge Kishner made in the Hunwartson trial. I believe that's correct as well. I would just say, so I don't think the parameters of those findings preclude making this motion. And the reason is this. They say hard cases make bad law. And a ruling that would include hydrazine as an adulterant of real water from time immemorial is not consistent with anything that was litigated and decided in Hunwartson or any other case. And how it comes in particular focus on this case, it's my understanding that Miles Hunwartson had exposure that went back to 2018 and perhaps 2017, I believe. From the beginning of this case against Terrible Herbst and the other defendants, Milo Herbst, H-U-R-S-T, not Herbst, but Hearst, Milo Hearst consumption, and what he stated in his representatives and the plaintiff stated in their fact sheets submitted that he first was sick in 2016. So right away you can see there's the rulings in Hunwartson or any of the cases I did not believe would eclipse and in Venn diagram or whatever form include the time period which Milo Hearst claimed to have first become sick from consumption of real water. And so with that in mind, Your Honor, it would be speculative to allow a ruling in a prior case that I don't think anywhere in there in those rulings that said from time immemorial.
Well, so backing up a bit, like I'm inclined to deny this one, and maybe I misunderstood your question. The reason why I'm inclined to deny this is similar to the reasons from the one we just did, not necessarily, or I wouldn't even add that, not based on the issue preclusion issue, but based on, hey, this is overly broad. And it does also go to an issue I think I've mentioned about defendants' position or on these types of arguments, like there are serious issues with the process of the creation of real water, and there's testimony that the same process was used from time immemorial, as you just mentioned. You know, the lack of quality, I already talked about this stuff, lack of quality control, etc. So I may have misspoke or I may have misunderstood you, because that's the type of reasons I would use to deny this. Again, it's without prejudice, question by question, answer by answer basis, and not necessarily because of what I did on the partial summary judgment.
Okay. I believe I understand that, Your Honor.
And I apologize if I didn't make sense at first, or if I'm still not, but that's the reason why here. So I totally cut you off.
No, you helped. So we're allowed on a question by question, answer by answer basis to raise these issues with plaintiffs' experts at trial.
Of course.
And so the denial is without prejudice to
Yes.
do that. And I will reserve, if I need to, any further arguments. Thank you, Your Honor.
I don't think I need to talk myself out of denial of this motion.
Yeah, so to be clear, you know, may not have said this if I already did, I apologize for repeating myself, but rulings on motions limine or provisional in nature, they're always without prejudice. Well, never say never, never say always, but generally, you know, they're subject to revision at and even during the time of trial. I will often say, hey, you know, just because I did something on motion limine doesn't mean that you don't have to object if appropriate. You know, there's case law that goes to that type of point, but they're without prejudice, and on the question by question, answer by answer basis, that's particularly true. Nevada Supreme Court said, hey, lower courts don't grant overly broad, you know, relief on motions in limine. So sometimes it's, hey, you'll have to, you know, make an objection if appropriate at the time of trial. So I'm not precluding, to be clear, any appropriate objections. But I'm denying it without prejudice for the reasons I stated on the last one, reasons here, but denied without prejudice.
Thank you.
That's, oh, are we on our last one for the day?
I believe so, yeah.
Number 8, okay. Oh yeah, yeah, okay. I think I said inclined to grant in part, preclude from order and opening the complaint of images except the US rocket. The rest, you know, closing argument's a different thing, and plaintiffs potentially can switch out the images using something innocuous. But welcome arguments.
Your Honor, Richard Bryant, bar number 15511 for real water. We're going to reserve on this one and wait to hear what clarifications.
Okay. Sure.
I think with this, we understand the court's inclination as far as it goes. I think it completely makes sense as far as voir dire goes. It is not in our intention during voir dire to show any of those types of images. I believe, and this court may recall, I know it'd be stretching back into the annals of time as far as the opening statements in the.
I mean, I do remember the images. I'll tell you, I do remember the images. I don't remember if they were an opening or closing.
Yeah, so typically an opening in order to try to start to present this issue, to explain to the jury some of the terminology that they're going to be used and hearing plaintiffs to use certain images and or explanations, analogies, etc., whatever word you want to use. And so we believe that it's also appropriate not only in closing, but also in opening in order to set the stage as far as the jury's understanding, try to get them to understand, you know, they're going to be hearing the word hydrazine a lot. What does hydrazine mean? You know, where does the word hydrazine come from? You know, as far as degradation goes, I know that they, you know, the degradation is the melting, one, as far as that goes, you know, it's easy to
Oh,
explain.
that's the Wicked Witch one?
Correct. You know, especially with Wicked, part 1 and part 2 coming out. I don't know if the sentiments that the counsel on the other side suggests is equally as, I believe Alphaba is beloved now, but stepping aside as far as that goes, you know, it is very clear, you know, it's very clear, and we've never stated, you know, defendants are bad because of this, and that's kind of what they're trying to suggest, and we have never stated that. You know, we did still pictures as far as, you know, this is what it looks like over time, you know, and it's a easy way for jurors to understand and put these complicated issues together, and that's all we're trying to do, is the, you know, suggesting that the jury will ignore all the evidence just because of this, you know, a singular photo is, I don't think that's the true, nor is that, you know, what the jury instructions, you know, suggest or otherwise, you know, especially with the wealth of information and evidence that you've already seen. We're pre-admitting here today, all the arguments. I don't think that is likely to happen. The analogies are permissible, explain hydrazine and degradation. They're not overly prejudicial. We don't, you know, have real water equals which, or that's not what the images are in any way, shape, or form. So we would just say that we understand your court's inclination. It's not our intention to do them during voir dire, but we would request and say that they are permissible as far as either openings and in closings go.
Thank you very much. You okay with my ruling?
I am, Your Honor, probably the biggest clarification.
But.
Hold on. Your Honor, I'm sorry, I know
No,
one
that's
right
okay.
and all that, just to make sure I understand the court's comment, is the court still inclined to go with the initial inclination?
Yes,
And we have no further argument, Your Honor.
okay.
May I make one representation?
Why don't you confirm, you can talk to him now and see. Okay, I mean, I don't know who's the boss over there, but there you go, so.
It's a madhouse over here.
So the court sticks with its initial inclination, grants in part, denies in part, grants in part to preclude use of all the images that are attached here, except for the US rocket in Wardier and opening. Clarification still is, plaintiff can potentially, an emphasis on potentially, you'll have to, if you want to, I'm not saying you have to, but if you want to, choose a more innocuous image. Run it by defense counsel, because people's definitions or understandings of what's innocuous differ as shown by this motion. It's denied in part, however, because I think those images are appropriate to use in closing, because closing's argument. So there you go. Any questions? Okay. Tomorrow at 1:30. All right.
Thank you.